Welcome back to Eyewitness News this morning, joined by Charlie O'Hara, here to answer your legal questions. A reminder, if you have a question, give us a call at 436-1212. Charlie, I wanted to ask you really quickly, we're talking about a couple different investigations that two different sheriff's offices are putting together right now and gathering evidence to recommend charges. Now, they can only recommend charges, right? Any sort of law enforcement agency can only recommend them to a prosecutor?
Yeah, the prosecutor's actually in control of what happens, and people don't really realize that. But the police may investigate something and say, well, we think we have a case, and the prosecutor, as an attorney, will look at it and say, I don't think we have a case. They actually have an ethical duty. If they're going to file a case, it has to be a case that they think is legally sufficient. I mean, they can't just harass people and hope to win, or file a case that doesn't have any merit and hope to win. It should be a case that they expect to win. Now, they don't always win, but when they file a case, they should expect to win it. So the fact that the police are pretty, they're all involved in it, and law enforcement's involved in it. So you want somebody a little bit neutral,
right?
And you want somebody to make a decision based on the law and try to be at least a little bit neutral before it gets to a judge. And then even here in Kansas, we have an additional thing that an affidavit of probable cause has to be filed by the DA or the county attorney, and they take that to the judge, and the judge reviews that to see if there's enough evidence to charge the person.
Interesting. And now there is also a very big difference between arresting charges and formal charges that are filed. What is that difference? People need to understand.
People can be arrested for something, but that doesn't mean they've been charged. They've only been arrested based on what the police think. I mean, if a murder happens and they think they have the suspect and they take him into custody, or she, and then they look at the evidence and it's not that person, or they don't have enough evidence, they should release them, and they have 72 legal hours to hold them.
Okay, big difference there. Very big distinction.
Yes.
We do have a caller on the line with a question, so hey, caller, if you're there, go ahead now and ask your question to Charlie.
Thank you, Charlie. I would like to know, if 3 people are named on a will, does number 1 have more power over number 3, or do they all have equal power?
I'm sorry, I didn't hear the whole question.
Oh, sure. If there are people named on a will, I believe if the person that's first named has more power than somebody who's named later in the will.
I think you're going to have to read the will as a whole and see what it says. I mean, whatever the will says is going to control if it's approved by a judge. So you're going to have to read the whole will and see. I mean, the fact that one person is mentioned first could be significant, it might not be significant.
I mean, will stuff, it can be pretty complicated if you're a member of a family and trying to separate that out.
And usually you need an attorney if you have any kind of assets, but actually it's kind of like a contract. It's what the person's wishes are, and the judge will usually try to read that and determine what the wishes are of the person that wrote it.
Yeah, definitely have an attorney involved when it's a little bit more complicated, more stuff.
Best.
Yes. Thanks so much, Charlie, for being here and answering the questions. Thanks for your phone calls.